Hello, welcome to the podcast. I'm Alan Craddock. I am the Deputy Commissioner for Hearings at the Texas Department of Insurance Division of Workers' Compensation. Just as a side, I will probably refer to the Texas Department of Insurance Division of Workers' Compensation as either DWIC or the Division from now forward, just because that's a mouthful to say. Let me tell you a little bit about my section, the hearing section at the Division. Our folks process about 10 to 12,000 disputes a year. We have 20 field offices and about 100 staff, a third of which are administrative law judges, a third are benefit review officers, mediators, and about a third are admin and docketing staff. What are we here to talk about today? What is a pod? Why are we talking about that at all? Well, a pod is a way to communicate with designated doctors, which serve a function in our system. So let's start with, what is a designated doctor? Well, a designated doctor is a third-party neutral that is assigned by the division randomly to answer medical questions that have to do with a case. So for instance, a designated doctor might be assigned to a case to answer a question about the extent of an injury. Well, let's say that the employee falls and lands on their hand. The employee says, I hurt my wrist at first, but then it goes and elbow and shoulder. Well, a designated doctor might be asked, well, what is the injury that was caused by the fall? Is it just the wrist? Is it just the wrist and the elbow? Or is it the wrist, the elbow, and the shoulder? We call that an extent of injury question, and that's going to become more important later. A designated doctor might be asked about disability. Disability is basically if someone hurts themselves at work, while they're off work, getting better, then they're entitled to a portion of their pre-injury wages. We call that disability, and whether or not the injury is stopping them from working. Designated doctors can also answer questions about what we call maximum medical improvement and impairment rating. And these are just big terms that mean this. At some point in time, the doctor's going to look at the injured employee and say, hey, you're as good as you're going to get. You're not going to get any better. What you have now, you will have for the rest of your life. And we call that an impairment, what you're going to have for the rest of your life. But that day that really there's nothing that's going to improve you anymore, we call that the date of maximum medical improvement. And those are other issues that a designated doctor can address in these questions. Well, how is a designated doctor appointed in our system? At some point in time, a party is going to file a request to have a designated doctor answer one of these questions. So for instance, if an injured employee has gone to the doctor, got their treatment, gone back to work, they seem to be doing okay now, either that injured employee or the insurance carrier will say, hey, I think it's time to have this person evaluated for that maximum medical improvement and impairment rating. So they would request a designated doctor. That request is on a fancy form. It's called a DWIC 32, and it's sent to the division where we have a designated doctor section who is responsible for going through this randomized list of doctors and assigning a doctor at random to do this evaluation and answer these questions. The appointment is set. The injured employee goes to the appointment, the designated doctor evaluates the employee, and then issues a report that comes back. Well, remember we're talking about pods in this case, and I told you that those are really communications with a designated doctor. The labor code and the rules are very concerned about the fact if parties start talking to the doctor, that somehow this neutral doctor that has no bias in the case, has no interest in the outcome, that the parties start talking to this designated doctor and they become influenced in some way. So the labor code and the rules talk about how parties can communicate with a designated doctor, and for the most part, they have to go through the division to do so. So they would ask their questions through the division, and then the division would communicate with the designated doctor. Well, that leads us, there are two basic ways that the division will communicate with that designated doctor. The first one is called a letter of clarification, and we refer to those as LOCs. And we'll go through these in more detail later, but an LOC is basically says, I just need the doctor to clarify something in their report. I don't need a new exam, I don't need a new report, I don't need anything new reviewed. I just need to clarify something that was stated. If a party wants something new reviewed by the designated doctor, or a new exam for the designated doctor to perform, then those we use what are called presiding officer directives. And these are where we get to the pods. But these presiding officer's directives and these letters of clarification from the division, they're really just both orders from the division to the doctor. It's just LOCs order the doctor to answer some questions, and the pods order the doctor to perform a new exam. So why do we call them pods? Well, fun fact, when we were developing this, we decided POO was not a good acronym, so presiding officer order was not an option for us at that time. So we decided to change order to directive so that we could have a fun acronym like POD. As another side note, we decided at that time that we were not going to label the people working in that section as POD people. Let's get into the real differences between these letters of clarifications, LOCs, and PODs, presiding officer directives. If parties don't agree on something, they'll file a request for dispute with the division, and that goes to our section in hearings. Well, we deal with issues, and y'all may be very familiar with the idea of the courthouse, and the courthouse doesn't deal with issues one at a time. They deal with the cases as a whole. If you get into a car wreck and you want a trial date, a judge in the court's not going to let you come in and say, hey, judge, I just want you to answer whether or not I need some money for disability for this week. And then I need to have another trial for this week, and I need to have another trial for the cost of my vehicle. Judge isn't going to do that. They're going to wait until the end, maybe a year, 2 years later when everything's over with, and they're going to say we'll have one trial for the whole case at that time. Well, that becomes problematic in workers' compensation, where part of the emphasis and the reason that the administrative process was put into place is that the legislature wanted to ensure that benefits were paid timely to injured workers. Because the idea is if you're injured at work, you need to get better, and we want you to get back to work. So they put in this process that we have where we can answer individual issues. We can answer, are you entitled to disability this week? And then have another case, are you entitled to disability this week? We are an issue-based system, so we may see the same parties come in front of us several times as part of a compensable injury. Well, when they request this dispute, that they're not agreeing about something, the first thing we're going to do is we're going to have them go to mediation. And mediation is, we call them benefit review conferences. And at a benefit review conference, you have a benefit review officer who's in charge of making sure to see what the issues are from the folks, see if they've got all the evidence they need for it, and also see if they can come to an agreement. If they can't, if at the BRC the parties still have a dispute ongoing, then the matter is sent to a contested case hearing. We call them CCHs. And at a contested case hearing, this is much like you would see in a trial. There's going to be a judge, an administrative law judge. We're going to swear in witnesses. There's going to be arguments, opening statements, closing arguments, all of that stuff. And at the end of that, the administrative law judge is going to issue a decision. Now, some folks aren't going to like that decision. They're not going to agree with the administrative law judge. And if they don't agree, they have a right to take and file an appeal to the appeals panel. They don't appear live in front of the appeals panel. It's all by written briefs. But the appeals panel will look at whether or not something was legally wrong. Not factually wrong, but whether the judge got the law wrong. And in that case, they might remand it or update the decision. But you have a right to go to the appeals panel. Now, if after all of this, a party is dissatisfied with the outcome, then they have a right to take it to the courthouse. So, that's the basics of the dispute resolution system that we have at the division. And again, we're going to be talking about mostly during that dispute resolution process, parties communicating with the designated doctor, because the designated doctor is a very important part of that dispute resolution process because, again, that's a neutral third party that is answering questions about a dispute the parties have. So let's start with these letters of clarification. What are they? Well, letters of clarification, again, are just for situations where we're going to communicate with the designated doctor to clarify some information that the designated doctor had at the time of the exam. Now, these can actually be requested outside the dispute resolution process, but the questions need to be able to be answered with no exam taking place and no new reports being reviewed. What are some examples where we would use a letter of clarification? Well, when the designated doctor issues a report on, remember we talked about maximum medical improvement and impairment rating? Well, they have to put a form on top of their narrative, their medical report, that has some information on it, and it's going to have the date of MMI and it's going to have the impairment rating on it. Well, let's say that in their narrative where they're writing the medical record, they say that the impairment rating is 10%, but on the form that they put on the front of it, it says 11%. Well, that's a discrepancy. We need to figure out which one it is, right? Now, does the designated doctor need to have a new exam for that? Not most likely. Most likely it's just a clerical error. Most likely the designated doctor can go back and go, oh, I meant it to be this number. What if all the way through the report, the designated doctor inadvertently calls instead of the left hand or left wrist injury, they call it a right wrist injury. But the right wrist wasn't injured. Nobody's claimed it to be injured, but it's a reference to the wrong side. It's not uncommon. That's a letter of clarification issue. Did you mean the left side? Maybe the designated doctor didn't sign the form. Maybe there's some other clerical issue with the form. That's a letter of clarification issue. Anything where the designated doctor, based on what they did and what they had, if they can answer a question that's mostly clerical corrections or those types of things, letters of clarification are absolutely the way to communicate with the designated doctor for those. Now, we don't use letters of clarification for new information. If after the designated doctor's exam, the treating doctor or a carrier-required medical exam doctor issues a new report, we don't send that new report back to the designated doctor saying, hey, this is a letter of clarification, tell me what you think. Because that report did not exist at the time the designated doctor originally did that exam. That's new information. The designated doctor didn't have that information because it didn't exist and couldn't have reviewed it at that time. It kind of leads me to one of the bigger issues about the differences between LOCs and PODs. For a letter of clarification, designated doctors generally don't get paid to answer those letters of clarification. Why? Well, because it's some task that they should have done at that time, or it's a clerical error or something where the error really is on them and they just need to correct that. For these situations, when somebody asks for a letter of clarification, either in the dispute resolution process or before the dispute resolution process, those requests go through presiding officers. Those presiding officers can be benefit review officers, the mediators, or they can be the administrative law judges. A presiding officer will look at the request for the LOC and say, is this appropriate? Is this one of those things that is just a clarification? Or are parties requesting a new exam or new information to be reviewed? That leads us to presiding officer directives, PODs. Well, PODs are communications with a designated doctor that say, hey, I need a new exam. There was something that you didn't get a chance to review that wasn't provided to you, and the designated doctor needs to look at that. Or we need a new report. We need you to evaluate the injury as if the elbow is involved, not just the wrist. So basically the doctor did the correct job at what they were told to do at the time of the exam, but the parties or the division need something new. This is the time for a POD, a presiding officer's directive. Most often, these will come up in dispute resolution. And most often, they will be identified by the presiding officer that they need to be done. So what are the circumstances that we would use a pod to communicate with the designated doctor? Well, a new injury. So if the designated doctor, when they evaluated the claim, they just rated the wrist for an impairment rating, well, there may be a dispute about the elbow. So now we need a rating for both the wrist and the elbow. So there may be a new injury. There may be a new issue that's considered, maybe disability. Maybe there's a dispute going on and disability has been added as a dispute or an issue now, and we'd like for the designated doctor to comment on disability. MMI and impairment rating, we're going to discover these are the vast majority of pods, and that we need a new impairment rating based on the new conditions that were decided, either by the administrative law judge or that will be decided by the administrative law judge. Maybe there's new medical records that need to be reviewed that, again, the designated doctor didn't have at the time they did the initial exam. And so now we're asking the designated doctor, tell us if these change your mind. Again, for a presiding officer directive, designated doctors get paid for those. Because again, it's something new that's being asked of them that's in addition to what they would have done before at the initial exam. Where do pods come from? Well, presiding officers found that they need to communicate with the designated doctor about something specific during the dispute resolution process. So for example, let's say that the parties get to a contested case hearing in front of an administrative law judge. And at that contested case hearing, the claimant is saying the wrist, the elbow, and the shoulder are all part of the compensable injury, and my impairment rating needs to consider all three. And the insurance carrier is arguing, no, we believe only the wrist is involved. And so therefore, we only need an impairment rating for the wrist. Well, let's say that the administrative law judge says, you know what, I've heard the arguments. I find that the wrist and the elbow are the injuries. Well, there's no impairment rating for that. Nobody brought one to the administrative law judge. So therefore, the administrative law judge is going to have to communicate with the designated doctor and order a new exam for the designated doctor to provide a rating for the wrist and the elbow. Now, long time ago, prior to pods being invented, the administrative law judge would tell the parties, hey, you guys go ahead and fill out a DWIC 32 and request a designated doctor, and I want y'all to request a designated doctor that says I want a rating for the wrist and the elbow. Well, that didn't always work out so well. You can imagine that there were some problems that came about because, sometimes the parties kind of hedged about what they were going to call those injuries. And sometimes they would delay things because maybe a delay helped them in that, and things didn't go off very timely. Well, essentially what that did, by relying on the parties to start the communication with the designated doctor, it just really caused disputes within disputes. Thus, the pod process was born. Here are the steps in the pod process that a presiding officer is going to go through. One, they're going to identify the need. That, hey, there is a dispute that is related to an issue that's not been addressed by the designated doctor yet. Then, they're going to write an order that tells the designated doctor exactly what needs to be considered and what needs to be done. Then, like other requests, it's going to go to the designated doctor section of the division where they will go to that randomized list, select a designated doctor, or if there has been a previous designated doctor on the case, that same one will be used. But an appointment's going to be set with that designated doctor. The injured employee will go to the appointment, there's an exam conducted, and a new report is issued. And again, presiding officers will be a part of this process, one, either for a pod identifying that the issue needs to be addressed, or for a letter of clarification to say, hey, no new exam, but we need this information clarified. So, Where does the division get its authority to be able to communicate with designated doctors? Under the Labor Code, under Section 408.0041, it says this is the request that is made for a designated doctor. And it says there's two ways for a designated doctor, the appointment to start. The first is at the request of the parties. If the insurance carrier or the employee, they can request a designated doctor. The second way is the commissioner's own order. So two ways, at the request of the parties or through the division's own order. Two ways to start the process for designated doctors. Now, under that same labor code, as we move down, it starts talking about this undue influence thing, this concern that, you know what, we don't want the parties really communicating with the designated doctor because they're supposed to be neutral. And it says, you know what, before the exam, the parties, the insurance carrier and the treating doctor, they need to send the medical records, obviously, to the designated doctor. And they can also send a medical analysis, a written analysis of just the medical. And they can communicate with the doctor through those, but that's it. Anything else that they want to communicate to the doctor needs to go through the division and division staff. Now, after the examination has been conducted, there is no contact from the parties after that. After that, the division is the sole way that the parties or that the division can decide to communicate with the designated doctor. Now, there are other reasons and other communications that can happen. They're not as much of a big deal. But so for instance, the designated doctor can in fact communicate with other doctors in the case. Now those other doctors can't start the communication to the designated doctor, but the designated doctor can pick up the phone and say, hey, I've got a question about this medical, and talk to other doctors or peer review doctors. And finally, there's an exception for the parties to contact the designated doctor, and just be real careful with this one, and that is for administrative matters. Let me explain what that means. The carrier or maybe the attorney for the claimant or the claimant themselves can call about, was an appointment set? Has the appointment happened? Have you issued the report? Those are administrative matters. They're not talking about the case. They're not talking about the issues. They're just trying to figure out if an exam has been conducted and if the report has been issued. That's okay. Now, let's say we've gone through this process. Under the normal situation, you have party identifies that, hey, I'd like a designated doctor. They fill out the form. It goes to the DD section. The DD section sets a doctor and sets the appointment. Well, what happens if the party realizes, hey, there's something off about this appointment? For example, I'm pretty sure that doctor that you just appointed as a designated doctor who's supposed to be a third-party neutral has actually treated the injured employee in this case. Well, that's not all right. So we don't want to waste all of the resources going to that doctor. So what will the party do in that circumstance? Well, they can request and they can dispute the approval or denial by the division of a request. So if a party has requested a DD and it gets appointed, somebody sees there's a problem with that designated doctor, they can dispute that. What they do is they file a request and we set a contested case hearing, no benefit review conference. It goes straight to a contested case hearing. And as long as that dispute is filed within 3 days of receiving the designated doctor's appointment, then the designated doctor's appointment is stayed, meaning it's kind of canceled for the meantime until after you go in front of an administrative law judge and they determine whether or not that doctor is actually able to conduct that exam. We know that if it's a request of a party, what about the commissioner's own order? What about pods? What about where the presiding officer has issued a pod, it goes to the DD section and there's an appointment set? Well, part of the process that presiding officers do in putting that information into the pod is they review all of that criteria and make sure that everything is correct. And so there's no process in the rules for anyone to dispute the appointment based on a pod, based on the division on their own motion filing or having the appointment done. So what do you do if you do see that there's something that's glaring and a problem? If that happens, we have folks that are called presiding resolution officers, pros. They got the best acronym in the entire division, of course, because they're called pros. And you can call each administrative law judge and each benefit review officer has a pro that is there to help facilitate communications with them. So you can call the division, get in touch with their pro and say, hey, you know what? This doctor actually treated this guy, or whatever your issue is, that will get to the presiding officer, either the ALJ or the BRO. And they'll make the decision about whether or not that needs to be changed. Make sure, though, that if you're going to file this and call into the presiding resolution officer, that you let the other side know as well, because we want all contact that goes into the presiding officers. Everybody needs to know about it. It's not a secret thing that's going on. So let's go back to the certification process with the MMI, impairment rating, and extent of injury. Now, again, extent of injury is just, hey, what body parts are related to the compensable injury? What needs to be rated? Maximum medical improvement, you're as good as you're going to get. You're not going to get any better. Medical treatment will not improve you. It may help with pain and stuff, but it will not improve your condition, so therefore you're at maximum medical improvement. And then you need to get an impairment rating that is a percentage of basically the harm or function of your body. The impairment rating itself, though, if it's less than 15%, whenever the 3 weeks of pay per percentage of impairment rating, whenever that's over, there's no more income benefits for the claimant in the system. Income benefits, money, is over. Medical treatment and payment for that can go on, but the money part is over for that injured employee. That's important to them. If that impairment rating is 15% or greater, there may be additional income benefits called supplemental income benefits that are available to the injured employee. And that's important to the insurance carrier. Also, whatever is rated in that impairment rating, the injured employee may be entitled to treatment for that for the rest of their life. These three issues together, the three of them combined, represent 43% of all the cases we see in hearings. That's a lot. Of those 10,000 to 12,000 proceedings, almost half of them involve these three issues. And they are so related to one another, they make things very complex. And they can bring up time, because here's the thing. I need to know the extent of injury before I can determine what date you reach maximum medical improvement, right? If it's a wrist and an elbow injury, you may need more time to heal than if it's just a wrist injury. So I need to know the extent of injury in order to determine MMI and what the impairment rating is. And then the impairment rating itself, again, that has to do with income benefits for the claimant, or whether or not they qualify for supplemental income benefits. And it can affect medical treatment in the future. So these three issues are a big part of the hearings dispute resolution process. Now, why would we need to get and be concerned about them as regards to communications with a designated doctor? Well, here's the thing. Imagine, again, that you get to the contested case hearing, and remember that situation I said where the insurance carrier has said it's just a wrist injury. The claimant believes it's wrist, elbow, and shoulder. And the administrative law judge has said, I've heard your arguments, I think it's just the wrist and the elbow. Well, nobody brought an impairment rating that rated just the wrist and the elbow. So after all the evidence is put in, and the administrative law judge goes through all of the medical evidence, and they make their determination that it's just the wrist and the elbow, there's no certification for the wrist and the elbow. Therefore, at that time, the administrative law judge has to send this presiding officer's directive to the designated doctor to get this new impairment rating, and that's not the ideal time for this. Why? Because it adds time to the dispute resolution process. It can take up to 60, 90 days. I've seen it take up to a year before that report comes back from that designated doctor. And that's because sometimes designated doctors go in and off the list. Sometimes there's issues with whether or not they'll take a case, and the year time frames are generally out-of-state cases where it becomes more complicated. But it adds time, and here's the other thing. Being in that contested case hearing, being in that trial, parties have an opportunity to make their arguments. They have a right to take the evidence and say, Judge, this is how you need to look at this evidence. This is what it means. And it's important for them to have that time to be able to make those arguments. Well, if they've already closed the evidentiary part, and then the judge determines its wrist and elbow and sends off for that report's going to come back, and sure, the parties have a right to make comments on it, but generally just by briefing. So they lose that valuable part of being able to argue the evidence when the evidence is presented. Wouldn't it be nice then if whenever it got to the administrative law judge in the case, that the law judge was pretty sure that there was a certification that was going to match whatever they found. And we kind of decided a number of years ago that there's basically 3 certifications that help us answer most of the questions, and most of the time the administrative law judge, having these 3 certifications, they will be able to go ahead and adopt a certification and not have to extend the case after the contested case hearing. Those certifications are this. 1, I need a certification for all the injuries that the injured employee is claiming. I need another certification for just what the insurance carrier has accepted. And then I need another certification from the designated doctor about what they believe the injuries are that are compensable in the case. And generally, by the time you get to the contested case hearing, one of those will be able to be adopted by the administrative law judge based on the case in front of them. Prior to June 5th of 2023, when we amended Rule 127.10, if extent of injury, MMI, and impairment rating were issues for the designated doctor to consider, then the designated doctor had to issue all 3 of these certifications: what the claimant wanted, what the carrier accepted, and what the designated doctor thought were the injuries. And they did that on all cases that came before them. On June 5th, 2023, the rule changed things. The rule changed to say this: designated doctor, when you do an exam and extent of injury, MMI, and impairment rating are involved, just give us 1 certification. And that's what you believe the compensable injury is. But then we turn to that dispute resolution process again, right? And in that dispute resolution process, remember, now, whereas we had, even though it was only 5 to 8% of the cases came through dispute resolution, at least in those cases, we had those 3 certifications, so at the end, the administrative law judge didn't have to manage the case and go back to the DD for additional certifications. We need in hearings a way to get those 3 certifications again. For just those 5 to 8% of the cases, we still need those 3 certifications by the time it gets to the contested case hearing. And it'd be really nice if we had those 3 certifications when it went to the benefit review conference, the mediation, because that's certainly going to help see if we can get an agreement in the case for the parties. We've decided in hearings, whenever we get a dispute that comes in on extent of injury, MMI, and impairment rating, we're going to use that time to get a pod out, get a DD exam done, and get the DD to issue those multiple certifications. Designated doctor appointment. By the time you request it, it's set up, the exam takes place, the doctor has time to write the report. That can add 60 to 90 days before that report comes back. In hearings, we have what we call, it's a performance measure. It's something that we report to the legislature, and the legislature has said, look, the standard we would like is on average the dispute resolution process from start to finish to take an average of 135 days. The legislature wants to ensure that benefits are paid timely, that medical is paid timely, so that not only is the injured employee healed, but they're also able to go back to work and be part of the workforce. So this 135-day thing is a big deal for us. Well, if we have to add another 60 to 90 days to get this designated doctor report, these alternate certifications in, that doesn't help us very much. So we had to figure out, how do we get this report, and how do we still make this process efficient and stay within this 135-day performance measure? A new process was created. We created a position called the Benefit Review Officer 1, who still is trained in mediation and can conduct benefit review conferences. But their job is between the day that we identify that there's a dispute that came in on extent of injury, maximum medical improvement, and impairment rating. Once they identify that, then they're able to start working to get a pod issued to the designated doctor to get those alternate certifications as fast as they can, so that hopefully we'll have them for the benefit review conference and ultimately the contested case hearing. So what the BRO 1s will do is, as soon as they identify these claims, they'll go through all of the forms and the files in the case, and they do a lot of work. They go through DWIC 45s, which are requests for dispute resolution. They go through plain language notices that are from the insurance carrier that tells everybody, here's what injuries we're disputing. They go through prior certifications in the case. They go through anybody that's issued a certification, like a required medical exam or a treating doctor. And they go through and they identify all of the injuries that seem to be part of the case. Then they're going to start working with the parties to identify those extent of injuries so that they can write that presiding officer's directive to the designated doctor. Now, when working with the parties, we know there are concerns. Parties get concerned about, if you're an injured employee, what if I tell you these are my injuries that I'm claiming, but later on I find something else? Am I stuck with what I told you? Insurance carriers, if I tell you that I'm not disputing this and later I decide I want to dispute it, am I stuck with my answer? And we understand that those concerns are real. We have forms that we will send out to the parties. The first one here is to the claimant, the injured employee, and this one is to the insurance carrier. And we'll have the medical conditions that have been identified. And we just say, hey, look, are you pursuing these injuries, yes or no? And for the insurance carrier, are they not disputed or disputed? Now here's something important that we've added to this to help with the discomfort that parties have about, what if I change my mind? And let me read it to you. It's the same for both the insurance carrier and the claimant. It says, and it is in bold letters in the middle of the second page, and it says, notice to parties. We request this information for mediation purposes only, and we will use your answers to order a designated doctor to prepare multiple certifications. Your answers do not bind you, and you may change your mind. However, inaccurate answers will likely cause additional exams and delays in the dispute resolution process. You should consult with your attorney or ombudsman. And the reason we put that in there is because we want parties to realize this is not a, ha-ha, we gotcha. You have to stick with whatever your answer is. This is the beginning of the claim. We want the best answer you can come up with so that we can get those alternate certifications in order to have an effective dispute resolution process from here on out. So at the benefit review conference, you're able to discuss things that actually exist and see if there's an agreement. And then when you get to the contested case hearing, you can make arguments about the evidence that's in front of you, and the administrative law judge can select a certification based on their findings of the extent of injury. So our benefit review officers, after they've gone through everything to try and identify the injuries, they're going to send this request for information to the parties. We're just trying to get this request out so that we can get the information back. And we ask that you please respond promptly. The quicker you're able to respond to that benefit review officer, the quicker you're able to fill out this information, the quicker they'll be able to issue that presiding officer's directive to the designated doctor and get those alternate ratings to assist in the dispute resolution process. They will generally call the parties within 3 days of this request for dispute resolution. When they call the adjuster or the insurance carrier rep, they're going to ask about, disputed and non-disputed conditions. Note, they're not asking what you've accepted. They're just asking what's disputed and what's not disputed. What injuries do you think need to be considered by the designated doctor for us to have a dispute resolution process that is worthwhile? They'll also ask the adjuster or the insurance carrier rep about whether it's a network claim or a non-network claim. There's just various pieces of information that will help us to get this presiding officer's directive out. Injured employees, they're going to ask, what injuries are you claiming and what injuries are you not claiming? Easy enough. They're going to verify your contact information, your address, email, any information that they can get about contacting you so that we can work back and forth with you. And for injured workers, they're going to explain this process. Because for insurance carriers, attorneys, and ombudsmen, they've probably been through this a few times. But injured employees, they want to explain this process and go through the information about what they can expect and what's going to happen. Now, they will work with the parties on what is agreed. Their purpose is not trying to get an agreement as much as it is getting the information they need to send out that presiding officer's directive, get the alternate rating so that the dispute resolution process is productive. If parties decide, if the insurance carrier decides, hey, I said I wasn't disputing this and now I am disputing it, or the injured employee says, hey, I wasn't claiming this before, but now I think this is related. If you change your mind after we've already had that designated doctor exam, then we're going to have another one. And that's going to extend the time that it takes to get the benefits paid to the injured worker. It's going to cause payment for a second designated doctor exam by the insurance carrier. It's going to delay the entire process. So being as accurate as you can the first time, and we understand things change, but be as accurate as you can, and it's going to help everyone. Once they get this information, they will issue the presiding officer's directive. They may ask other information on there. They may ask if there's a new extent of injury condition that hasn't been considered. They may ask the designated doctor, do you think this is related or not? They're going to ask for those multiple certifications. What the insurance carrier has accepted, what the claimant claims to be part of the injury, and they probably already have the designated doctor's exam where the designated doctor issued a certification on what they thought was related. Now, there are other considerations that the Bro 1 may take. So, for instance, I told you that date of maximum medical improvement is the date that your doctor says you're not going to get any better, whatever you have now, you'll have for the rest of your life. Well, that date generally cannot go past about 2 years from the date of your injury, just a little over. We call that statutory MMI, and as of that date, they have to give an impairment rating no matter what. So if you're past that date, then the Bro 1 will probably have to adjust the pod to let the designated doctor know that. You can't pick a date of MMI past this date. Based on the injuries that have been added or looked at, the doctor qualifications. If the doctor isn't qualified to look at an extent of injury, so for instance, maybe a brain injury has been added, well, those are types of things that the Bro 1s will look at. They'll work with a designated doctor section to get the designated doctor appointment set. Then they'll work with a designated doctor's office and the injured employee to make sure that they know when it's set, that it's been conducted, and get the report back. And then that report will be sent to the parties and to the benefit review officer. Then we have the BRC. And at that BRC, hopefully we have those alternate ratings and we have them without delay. If the parties want another pod at that BRC, if they add conditions or subtract conditions, it's going to delay things. And it is certainly up to the discretion of that benefit review officer about whether or not they issue that pod. It's also up to their discretion about whether or not they go ahead and set the matter for a contested case hearing. And part of what they're going to look at is how much did the parties participate in this process with the Bro 1s? Did you call us back? Did you give us the information? Did you help get the extent of injuries identified so that we could get the pod? Well, that's it. That's all I've got for you as far as the process and what we're looking for and the new process that is out there. At this time, we're going to open it up for questions. You can send your questions to the chat area, I'm going to be here and I'm ready to answer those for you. Thank you.
I want to thank everybody for attending today, the CompCourse webinar. I hope you enjoyed it. I hope you learned a little something from it. Pods are not the most interesting topic, but hopefully we've made it at least a little bit interesting for you. And just a reminder, you must stay on for the question and answer to receive continuing education credit. We will begin with questions on the question and answer tab and the chat. Just enter your questions into the question answer tab or the chat, and I will try to get to everybody's question. So let's go on with this. I've got to see if I can read as fast as y'all type. So let's see. Let's see. I think the presentation should be available at some point. I hope the presentation folks will answer that for you. Thank you for saying such nice things about the presentation. If the patient gets an impairment rating, then later on gets surgery, does he need a new BRC? Well, that depends. Obviously, an impairment rating can become final. If it becomes final, then there would not be any increase in the impairment rating itself. The impairment rating, again, is only an income benefits issue. An impairment rating is basically your impairment rating is you get 3 weeks of benefits for every percentage point you get. So it's a monetary thing. If the claimant has surgery or additional injuries are added as compensable later on, obviously the claimant gets medical for the rest of their life in regard to those conditions. That's not affected. But the impairment rating itself is just a stamp in time for the payment of basically benefits for impairment income benefits. Let's see. Recording today was posted. Pod. So for disputing a pod, there's, as I looked in there, there's not really a dispute of a pod because there are 2 ways that we get a question to the designated doctors. The parties can request that we send a letter of clarification or a pod, and then also the division through the commissioner can decide to send one. The request from the parties is actually either the approval or denial of that is what allows for a dispute. But the decision of the division to decide to send it is not part of the dispute process under the rules. And that makes sense because, I mean, if you've got an administrative law judge or a bro who is sending out a pod, it's going to come back to them to decide whether or not your dispute. So they've already considered those things. If there is something if there's clerical on there, or there's some misinformation, as I said in the presentation, go ahead and call the presiding resolution officer for that presiding officer, and just let them know, and they'll take that into consideration. There's no need for a process or whatever. All right, let's see. Is there a means by which TDI can verify a current treating doctor? I've had a few recently where the TD was changed months ago and the IW informs me during the exam. Then the chase is on to get the new TD records. That's actually a little outside my area. The designated doctor section under Mary Landrum, I'm not passing that on, but I will pass this question on and have Mary get back to you as far as what can be done with that. That's a little outside my scope of expertise as far as how to track that down. Let's see. Does the extent of injury issue have to be raised on the DWIC 45 when disputing MMI and impairment rating in order to trigger the Bro 1 process? So what'll happen is that if we see as part of the dispute process at the beginning, if we can identify that there is an extent of injury issue, and the Bro 1s I can't tell you how hard they work. So proud of them, but they go through the files and look and they see, and sometimes they will see if only MMI and impairment rating are on the dispute, they will look behind that to see if there's something more with the extent, see if we need to get this process going. But yes, it's always better to have the extent, if the extent of injury is one of the issues, then raising it on the DWIC 45 certainly alerts us to it and make sure that we get on it in order to get through this process and get those pods out. Are you expecting an increase in pods now that the carrier compensable injury is no longer listed on the 32 form? We have not seen that. This has been for quite some time, and we have not seen that that issue. When do the forms start getting used? There's not any new forms. The pods and the LOCs have been used for a long time, and they're just continuing. It's just we're going to be using them now more for the multiple certifications. Does the pod take the same amount of time to get scheduled as submitting a regular DWIC 32, or does it take priority? We like to think that it takes some amount of priority because we've got to get through this dispute process. But the DD section does work with us to make sure that we get those done. But obviously, every designated doctor exam is important, and they work through those to get those all set. Let's see, a recent BRC on disability turned into a $5 extent, and there was no offer by Bro to request pod on extent. The pods from the Bro ones will only be used if whenever the DWIC 45 is filed, they can identify that MMI, impairment rating, and extent of injury, those three issues are all in dispute. That's the only time the Bro ones will get involved to get those multiple certifications in that pod, through a pod. Have you had a situation where an injury is accepted past a statutory date? Yes. Yes. There's plenty of situations like that. Can we request a pod, Bro 1 process, or is it only at their discretion? They will do it in every case where there's MMI, IR, and extent of injury. There's no discretion on that. They're going to do those. But certainly if you have some assistance to help them out, call the pros, and they will absolutely get that information, and we'll get that process started. We're not doing this just to add some highlights to the system that we can talk about in a podcast. We did this because essentially, as I said before, the 93% up to 93 to 95% of all cases never see the dispute resolution system. And as a consequence, they don't need multiple certifications in all those cases. And so that's the reason why it was limited now to just those situations where it comes to dispute resolution. And we're doing our best to facilitate those at the beginning of the process so everybody has that information. Alan, we cannot and should not refuse medical records from the IW. That's just some commenting that's going on. If there's no lost time on a claim, would a stat MMI date still be no later than 2 years, as you mentioned? No, it's 2 years from the 8th day of disability. So 104 weeks from the 8th day of disability. So the stat MMI date would not have run by then. What is the difference then from Bro 1 identifying the issue and the Bro not raising the issue under dispute resolution process? Let's see. So I'm trying to figure out where the Bro 1 is basically working with the parties to identify the extent of injury issues, which is what the Bro would be doing at the BRC. It's still, the parties dispute. So what they believe are the extent questions are what's going to drive the claim. I hope that answered that question. If not, you can bring it back up and I'll see what I can do. Let's see. Questions. Since we're doing this webinar now, I've got 2 screens of questions going. So pardon me a second. So the claimant states the info in the DD report is inaccurate. It is an actual statement the examiner claims she made, and she denies she made the statement. Does she contact a pod? It depends on what's in the report that's inaccurate. If somebody says it's inaccurate that this is part of the compensable injury, what a decision that the designated doctor made, then no, that would not be a pod. If something was, whether or not they had looked at the where they said right or left or something like that, something that's clerical in nature, something that's simple to answer. Those types of things would be what is available for a pod. Can either party stay a DD exam that is set pursuant to a pod? No, no. Again, only the approval or denial of a party request for a DD is subject to the disputes and subject to being stayed. Is the new process with pods and bros intended to eliminate the bifurcation process? No. No, that was something we set out some time ago, and parties can still use the bifurcation process. This is not intended to eliminate or replace that. In fact, I would hope that folks would use that where it is absolutely appropriate. No problems at all. All right. It's like speed questions here. Let's see. I've got nothing else in here. Anybody else have any additional questions that I can answer? I'll do my best. Okay, if the DD refers the IW for a neuropsych exam because the care accepted a head contusion, which resulted in 5% impairment rating, can we get a pod? I guess if there's a question about the extent, whether or not, the contusion is actually a brain injury and that sort of thing, then that extent question seems like that might be a pod, but it would be a case-by-case type basis, I think, and would have to find out more about that extent question. These are all good questions. Appreciate them so much. Well, we are coming to the end now, and so thanks for joining us today. And, if I didn't get to your question or you feel, just feel free to reach out to me here at Hearings. You can reach me at Allen, ALLEN.Craddock, CRADDOCK at tdi.texas.gov. Feel free to let me know if anything comes up that I can answer or help you out with. I appreciate your time. After the webinar ends, there's going to be a short survey that's going to pop up. It certainly helps us to make these webinars the best we can. And I hope everybody has just a great day. Thank you so much for attending. Thank you.